Hi friends, welcome to Shorthand Hub channel. This is Harinaganand, Idumudi Shorthand instructor. I am conducting both online and offline classes to the shorthand students for learners and also lower, higher and high speeds. For the shorthand students, I am offering general and legal dictations. This will help you to crack the shorthand skill tests. Those who want to join the Telegram group can join through the link given in the description box. Dictation passage links will be given in the description box. Get ready for the dictation. Ready? One, two, three, start. The Honorable Supreme Court pronounced judgment on the lines that courts should not withhold the right of an accused for bail irrespective of the nature of crime, and that refusal to grant of bail is an unjust punishment. Speedy trial is the right of every person under Article 21 of the Constitution of India, and the rights under the said article apply irrespective of the nature of the crime. The Supreme Court has held in its latest judgment. The decision was not just a theory that can be interpreted conveniently by the concerned. It was a virtual how to do order when the apex court said the prosecution should not be object to bail on the plea that the charge is serious if a speedy trial is not possible. Great jurists, including the legendary Justice, have said that bail is the rule and jail is an exemption, but Indian courts, especially the trial courts, refuse bail applications under one pretext or the other. The Chief Justice of India is on record recently criticizing this method of the courts to grant bail. But it is not just the trial courts. It was not too long ago that the Supreme Court had suspended the bail granted by a high court to the Professor Sai Baba, saying that the charges against him were serious. This country has been witnessing the curious occurrence of political leaders being arrested and thrown in jails under the Prevention of Money Laundering Act 2002. Even while the investigation into scheduled crime would have reached nowhere. This is only because getting bail under the law is next to impossible. It will be a great service to democracy in India if the courts rose to recognize the constitutional mandates and protected the rights of its people against the attack by the state machinery. Observing that a question paper leak has occurred and that a retest may be necessary if the sanctity of the NEET 2024 is lost. The Supreme Court on Monday sought information from the National Testing Agency and the Central Bureau of Investigation regarding the timing of the leak and the duration between the leak and the actual text. During the hearing, the bench noted that if the sanctity of NEET 2024 is lost and if the leak of its question paper has been propagated through social media, then a retest must be ordered. It stated that if the question paper leak was occurring through Telegram, WhatsApp, and electronic means, then it spreads like wildfire. If the sanctity of the exam is lost, then a retest must be ordered. If we are unable to identify those who are guilty, then a retest must be ordered, the bench observed while hearing the matter on Monday. Let us not be in self denial about what happened, it said. The top court questioned that assuming that the government doesn't cancel the exam, what will it do to identify the beneficiaries of the question paper leak? There is no question that a leak of the question paper has taken place. We are determining the extent of the leak, the bench observed. The apex court also requested the number of wrongdoers identified so far and the methodology adopted for the paper leak. One thing is clear, a leak of the question paper has taken place, said a bench headed by Chief Justice of India. The top court stated that it wanted to know how many people benefited from the question paper leak and what actions were taken against them by the center till now. How many wrongdoers' results have been withheld and what is the geographical distribution of such beneficiaries, it asked. The bench emphasized that the extent of the question paper leak and the beneficiaries across geographical boundaries must be ascertained before the court can order a retest for the medical entrance exam held on May 5. The Supreme Court has scheduled the next hearing for July 11. The court is addressing a batch of pleas alleging irregularities in the NEET. The top court directed the investigating officer of the Central Bureau of Investigation, which is probing the allegations of malpractices, impersonation, and cheating, etc., to prevent a report on the status of the investigation. Referring to the legal position on ordering a retest, the top court said that it would need to scrutinize whether the alleged breach occurred at a systematic level, whether the breach affected the integrity of the entire exam process, and whether it is possible to separate the beneficiaries fraud from the clean students in a situation where the breach affects the entirety of the process and it is not possible to separate the beneficiaries from others. It may be necessary to order a retest, said the bench. The top court instructed the investigating agencies to disclose the steps taken so far to identify the beneficiaries of the wrongdoing. Stop. If you want to get more updates, please subscribe our channel. I am providing passages like Kailash Chandra to SSC students. The shorthand dictations which I offer 80 and 100 are helpful for competitive examinations such as the State Board of Technical Education and Training, SSC Stenographer grade C and D. So everyone can write these passages. Apart from this, I am also providing 120, 150 and legal dictations. Thank you.